Welcome to my channel. Please like, comment, and subscribe. Negligence under the Jonas X. Seamen working aboard seafaring vessels are entitled to maintenance and cure in the case of injury. But if the employer is negligent, they are entitled to further compensation. The Jonas X is similar to workers' compensation for other types of workers. The Jonas X allows for compensation for seamen much as the federal employer Reliability X provides compensation for railroad workers. The main difference between workers' compensation and the Jonas X is negligence. For other types of employers, workers' compensation is available in the event of an injury. No matter who was at fault for the injury, Jonas X negligence means that an injured seaman is entitled to compensation when the employer is negligent or at fault for the accident. And then next about what is negligence. The simple definition of negligence according to the Jonas X is the failure to use reasonable care. Reasonable care means taking the expected care for the safety and well-being of employers that any prudent person would. Being negligent means either doing something that a prudent person would not, or failing to do something a reasonable, prudent person would do to protect themselves, employers, and anyone else aboard the vessel. And then next about negligence and caution. Negligence does not always cause accident and injuries. An employer may get away with negligent behaviors and be lucky enough to avoid accident. To prove negligence in the event of an accident or injury, you have to prove both that the employer acts negligently and that this negligence causes the accident. The negligence has to have played a part in the accident, even if it is only a small part of, or if there were other factors involved. Next, and then example of the Jonas X negligence. The definition of negligence is broad and leaves room for a number of actions or inactions on the part of an employer tasked with the responsibility of keeping a crew safe. For example, negligence could include a failure to provide adequate training for the crew. If crew members have not been properly trained to use equipment or have not been trained in safety procedures, this lack could easily lead to an accident that causes injuries. The employer is also responsible for maintaining a vessel in a state that is safe for the crew. If the deck is cluttered with adequate equipment or the equipment has not been maintained properly, this can lead to accident. Not having the right equipment to do a job is another potential problem. The employer must also make sure that the vessel avoids some or other kinds of weather to the best of his or her ability in order to keep the crew safe. Confrontations between crew members could also fall under the category of negligence on the part of the employers. If you are assaulted by another employer, your employer could be negligible for allowing conditions on the vessel that lead to conflicts and violence. And then next about a low burden of proof. The good news for seamen injured on the job is that he or she has a low burden of proof when it comes to negligence. In many other types of negligence causes, the plaintiff is expected to prove that the defendant was the major cause of an accident. In maritime injuries and accidents under the Jones Act, the seaman only needs to prove that negligence on the part of the employer played any role in causing the accident, even as little as 1%. While burden of proof is low for a plaintiff in a Jones Act claim, it is still important to be prepared to make your case if you find yourself in this situation. A big part of this is having an experienced attorney on your side, fighting for your rights to compensation. And the next, the Jones Act and contract worker. The Jones Act is a law that gives right to seamen, as described by the law and determined by court cases. If you are a seaman, this law gives you the right to sue your employer if you are injured. You meet all the qualifications and you can meet the low burden of proof that your employer negligence contribute to your accident. Getting this compensation can be a big relief if you are injured, have medical bills, and are unable to work for a period of time. Unfortunately, not all workers will qualify under the Jones Act. Whether or not a contract worker qualifies depends on many factors. Contract workers are not always included in all the rights that an employer has, but there are exceptions. The Jones Act does provide for independent contractors who are not officially employed by the owner of a vessel but are working there under contracts. In certain situations, if you are working as an independent contractor and not an employer of a vessel and you have been injured while working on it, you may have right to. It's important to understand what those rights are and exactly whether or who you qualify under the Jones Act so that you can get the compensation you need. Thank you for watching this video. Don't forget to give like, comment, and subscribe